This is Christopher Smith with a Liberty Minute.
Hello, America. Welcome to the Friday edition of the Liberty Rant. As many of you may know already, the U.S. District Court Judge Vaughn Walker, the openly gay judge who had the unmitigated gall to render one of the most licentious rulings in U.S. court history, thusly turning the 14th Amendment on its head, offering one of the most lopsided opinions on case law in U.S. history regarding the subject of same-sex marriage. Now, I'm not going to rehash the whole sordid ordeal, just to say in the most conspiratorial sense that I think the judge rendered his decision on purpose just to get it to the Supreme Court, where it'll ultimately be shot down and the bets settled moving forward. But again, that's just me erring on the conspiratorial side there. But what I briefly want to touch on today is arming you with the knowledge of how to disarm and discern social justice arguments by proponents of same-sex marriage who use this in attempt to justify the legal protection of a behavior. What we have to do first is address the section of the 14th Amendment that addresses this more appropriately. The 14th Amendment reads in Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any such law that shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. It is clear based upon the understanding of this reading that voters in the state of California simply had their rights impugned by fiat activism from the bench. Due process, or in this instance, the due process of referendum, was completely ignored by a moral equivocation play of what was proper to consider a violation. It was the language of the decision that bothers reasonable thinking people and thought to be quite unnerving. It was though Judge Walker figured that people who engage in homosexual behavior can't seem to separate their sexual activity from their citizenship. But going down that road takes us down a whole different avenue of thought, so I digress. If we apply logic using constants versus variables, we'd learn quickly that people who engage in the behavior of homosexuality are still people, and the constant in that equation are the people. The variable is their behavior. They aren't constantly engaging in the act of homosexuality, which makes it the variable, therefore subjective, not objective. The Constitution was created for people, not their behavior, which rendered this decision as irrational as it was unconstitutional. So when supporters of same-sex marriage come at you with emotional arguments over a logical basis for their position, say like marriage is a right and equality for all, well, red flags ought to be going off like Lenin Day in the Red Square. First, realize that they're lobbing two arguments, both of which are completely brainless on their face. Marriage is a right? Oh, really? Is it now? If marriage was a civil right, then we'd have polygamists and bigamists who would have the legal right to marry, and that simply is not true. States have the privilege, according to the Constitution, to regulate marriage because it impacts the general welfare of society at large, just like driver's licenses or a business license does. Marriage and driving are both privileges and can be revoked if an issue of safety or moral turpitude is violated. It's that simple. Who can you quote on whose authority this can be regulated? Try Article 1, Section 8. It echoes the preamble when it tasks Congress to protect and defend and provide for the common defense, also promoting the general welfare and protect, most importantly, the defense of the posterity of the United States and the Constitution itself. The operative word to consider here is posterity, which means the future of the nation. Equal protection is very important, and it is the glue the Constitution is held together with. It means that each generation should have the same protections the previous generation and then the future generation should have. Because if they don't, that's not a constitutional guarantee. That means Congress did not apply. That means the courts did not uphold. That means the executive office did not defend the equal enforcement, i.e. protection of the laws from state to state, and those did not take place. Then you don't have a constitutional guarantee worth a damn when you change the protections from one generation to another. Well, the latter may fit within the auspices of situational ethics progressives like to promote with their lie that the Constitution is somehow a living, breathing document. instead of the mainly immutable rule of law that we currently have. Secondly, equality for all. This argument can be easily dispatched. The law protects people equally and provides no such protection for their behavior, simply because all things aren't equal. Being broke isn't equal to being wealthy, evil is not equal to good, and so on. The rule of law ultimately evokes the objective and abstains from the subjective. It's that simple. I also want to address this huge fallacy that you are somehow a bigot because lifestylers disagree with you and you disagree with their philosophic deviation from reality on what the definition of the word bigot is. Bear in mind, first off, any fool who has the gall to morally equivocate natural ethnicity with a deviant sexual proclivity, this person has more issues than Newsweek, and you don't even need to give them the time of day. And you can tell them I said that. So our framers protected the inalienable rights. The creator, they referred to in our Constitution as the author and endower of our rights. That is God Almighty. Our framers had already left that up to us to define, except for severe cases where the nation's sovereignty is in jeopardy. The express purpose of law is to discriminate against behavior. It draws clear lines on what falls short of the accepted standard. I'd ask, do you have a problem with that? Because that's what law does. So if someone comes to you and says, well, the law is discriminatory, take the wind out of their sails on it and own it and tell them, well, it wouldn't be much good if it didn't. Say that and watch them hit the ground in a stop, drop, and roll grand mal hissy fit. But no, you spoke the truth. What do you think? I'm Christopher Smith.